Thank you for coming this morning, folks. We'll get started here in just a second. Just a few housekeeping things. This is the news conference on the South Platte River lawsuit. We have Governor Polis, Attorney General Phil Weiser, and then the State Water Engineer, Jason Ullman. We will have remarks from each of them, and then there'll be a Q&A afterwards. And so you should be getting a news release in your inboxes very shortly, okay? Which also has a link to the brief that we filed with the Supreme Court this morning. Without further ado, Governor Polis.
Yeah, come on up. And we're also joined by Dan Gibbs, Department of Natural Resources, available for questions. Attorney General Phil Weiser. Thank you for joining us as we share the latest news as we are aggressively defending our Colorado water users and rights and landowners and our rural economy. Today we filed the legal response to Nebraska's premature and unfounded lawsuit to the U.S. Supreme Court. We of course know the importance of water in Colorado, and we have always faithfully honored the century-old South Platte Compact and all water agreements that Colorado is partner with, and we will continue to do so. But we won't sit by while Nebraska chases a meritless and premature lawsuit that circumvents their rights under the agreement and threatens our water resources and our rural communities in northeastern Colorado. I want to thank Attorney General Phil Weiser, Department of Natural Resources Executive Director Dan Gibbs, State Engineer Jason Ullman for their steadfast partnership, as well as the line attorneys that worked on this important filing. The stakes are very high. And in Colorado, we take serious action with regard to serious concerns. Unfortunately, our neighbors in Nebraska do not seem to be pursuing it the same way. The unfounded and unserious lawsuit filed in Nebraska is just that, a meritless escalation. We were surprised by the lawsuit, and we've frankly been surprised by the boondoggle that has been this entire Nebraska project. We've long said we're ready and open to meet in good faith with Nebraska, to honor their rights under the compact. In fact, before the lawsuit was filed, we were in regular meetings with one another, and once the court dispenses this meritless lawsuit, we are ready to return to the table and honor the compact. Colorado, of course, acknowledges the contract and Nebraska's right to build the Perkins Canal, but there's been no progress to speak of. There was filing for eminence domain, then withdrawing from the filing of eminence domain, and there is, of course, no evidence to their claim that we've in any way stood in the way of progress, and that assertion is ludicrous. They haven't, frankly, taken any steps that we could have even stood in the way of, even if we wanted to, which we don't. We want to make sure that Nebraska does not scapegoat or attack our communities in northeast Colorado based on a misreading of the conflict, based on a misinterpretation that they somehow have leverage above and beyond their rights under the contract, speculation about future disputes, or desire to renegotiate what we agreed 100 years ago. This is really a runaround of the normal process to try to get the courts to take an extraordinary step to insert themselves in agreement between the two states, which Colorado has every intent to continue to honor. As a headwater state, we successfully and effectively manage many compacts on all sides of Colorado, and we have very strong relationships with our downstream states. We will continue to honor the South Platte River Compact and all of our river compacts as we always have. We are also here to make sure that Nebraska honors the letter of the compact as well. With regard to the specific rights of Nebraska and Colorado, we stand ready to defend Colorado's water users, our strong agricultural industry, and our rural economies. And with that, I will turn it over to Colorado's Attorney General, Phil Weiser.
Thank you, Governor, for your leadership and partnership, and thank you to our colleagues in the Department of Natural Resources for their tremendous partnership and the lawyers who've worked on this team. It's truly an extraordinary effort. Colorado is very well served building the talent in state government to handle matters like this. And at the outset, I will say not all states have the same investment that enable them to manage water as thoughtfully, creatively, and responsibly as Colorado does. We're here today to talk about the South Platte, which is a river that starts in Colorado. As Governor Polis knows, we're a headwater state. The only other state in the union who has only rivers that start in that state is Hawaii. We are unique, and with that comes responsibilities that we are prepared to manage, and we do. We also are prepared and will always defend the rights of Colorado. And the landowners in northeast Colorado are depending on us to fight for them. I was there in Julesburg last month, hearing from local community members concerned about Nebraska's behavior and viewing it very much along the lines of what Governor Polis said, an unserious boondoggle that has continued to perplex us as they've pushed it forward. There's two issues that have been raised at the Supreme Court, neither of which have merit or warrant the court's attention. First, the claim that we're interfering somehow with their effort to build a canal. As I'll explain, that's not the case. Number two, they've said that we're somehow in violation of the existing compact. I'll make this point right now. That's a claim that they only asserted once they started talking about the canal, even though the facts underlying that purported claim on their theory held before. We see that as baseless, as I will also explain. Let me mention at the outset, what is the standard for the Supreme Court to even take this case, which is what we're now talking about, whether the court takes this case. One is, they've got to show a threatened invasion of their rights, and the fact that they may be having some second thoughts about whether to do this or how to do this, that's not good enough. Number two, if there are other ways in which these issues should be addressed, other steps that have to happen first, that is a bar to the Supreme Court taking this case. And that is the situation here. Let me start with this point about the canal and the purported statement that we might be interfering. As the governor said, we're not. They have barely started the permitting process, which is the foundation of any project. That process can take easily 3 years. And in this case, it's barely started. They haven't really begun any condemnation proceedings. As the governor mentioned, they initially sent out a couple letters, they then withdrew. It's important to let these processes move forward and not to jump the gun, if you will, in the Supreme Court getting involved, because there's so much uncertainty right now as to whether or not this will happen or what it even might be. If there is actual progress in building an actual canal and issues actually arise, that's the point at which the Supreme Court might want to take a look at them. The court knows well not to take issues before they are truly ripe for adjudication, and that is what we believe the result will be here. Second, let me talk about this claim that there's any interference with Nebraska's rights under the compact. This is a claim that we've explained is not substantiated. Nebraska has not done their homework, and they have failed to sit down with us so that we can work towards an understanding about what's going on. This compact is unique because all Nebraska has are the rights of seniority as of the date of the compact. There's no delivery obligation under the compact, and their claims need to be more carefully analyzed before there's any real dispute, because we don't see there as being any dispute. We don't see us as taking any action that is in violation of the compact or harming Nebraska. These hypothetical concerns they've raised do not warrant Supreme Court review. What they do warrant is more conversations, which had just barely begun to happen before this surprise lawsuit took it the turn it did. We are confident that we are in a strong position here. We see these claims as premature, as speculative, and not ripe for Supreme Court decisions. If there are alternative forms that later generate any real disputes, then we could find ourselves at a different moment. But at this point, the Supreme Court should not take this case. We believe they won't take this case, and that we will continue to defend the rights of Coloradans and to protect Northeast Colorado landowners. As I've said at the outset, we have a great team representing our state, and that team works together effectively on an interdisciplinary basis, which means our lawyers work very effectively with our state engineer, to whom I will turn over the floor. Thank you.
Thank you. As AG Weiser said, I am the state engineer. My name is Jason Ullman. I want to first thank Governor Polis and AG Weiser for their support of the Division of Water Resources. As state engineer, I'm also the director of the Division of Water Resources. My team is responsible for administering water rights in Colorado. What does that mean? That means that we're responsible for ensuring compliance with the South Platte River Compact, as well as making sure that senior water rights in Colorado get the water that they're entitled to. In the South Platte, what this means is that water commissioners in the South Platte are the ones curtailing junior water users to meet the needs of senior water right holders, including the rights prescribed for Nebraska in the compact during the irrigation season. I can assure you that my staff are thoughtful, knowledgeable, and experienced in administering water rights in Colorado. We have over 140 years experience doing that. And they are committed to ensuring that we meet our obligations to downstream neighbors, of which we have many, as was explained, but while protecting the rights of Colorado water users to use water they're entitled to under those agreements. In doing that work, I can also tell you that we are committed to working with our water users and the state of Nebraska to resolve questions and concerns before they grow into factual or legal disputes. As the governor mentioned, we were engaged in just those types of discussions with Nebraska regarding the Perkins County Canal when they filed their petition with the Supreme Court. In fact, I was part of a small team that met in person multiple times in Nebraska, or with Nebraska, in an attempt to learn more from them about their plans for the proposed canal. At no time during those discussions did Colorado deny Nebraska's right to build the canal as contemplated in the compact. Merely holding Nebraska to the contours of the rights prescribed by the compact does not constitute interference or obstruction. Their action of asking the Supreme Court to take the case on July 16th took us by surprise, especially given that we had another meeting scheduled in just a few weeks. Until Nebraska started talking about the canal, they also never suggested that they were concerned Colorado was not meeting its obligations during the irrigation season. When they did start raising these other questions about irrigation season obligations, we responded by phone and in writing and had brief discussions about it during our meetings about the canal. We also thought that Nebraska would continue to engage with us to resolve these questions as we have done for over 100 years. Up until Nebraska filed its petition with the Supreme Court, the two states have found ways to resolve whatever questions came up between them. I hope that we can get back to that method of resolution, and I hope that once all of the briefs are filed, that the director of Nebraska's Department of Water, Energy, and Environment will call me to resume those discussions.
We're now open for your questions. Mary Ann.
Thank you so much. Yeah, you said that Nebraska has the right to build a canal, but at least the plans as they were outlined in the compact 100 years ago go onto Colorado land in order to build that canal. And your position, it seems to me, has always been not to fight against the eminent domain claims that Nebraska was asserting originally. So this seems like a conflict here. Can you explain that?
Sure thing. Nebraska has the right under the compact, as you said, to build a canal in Colorado. That is a right that they have never chosen to act on, even though there have been a few moments where they have explored the option. It would be an ambitious and unique sort of project to undertake. If they choose to undertake it, they need to follow the process, which starts with this permitting process that they've barely even commenced. And then if they're going to move ahead with any effort to condemn land, they'd have to follow the process for condemnation. Our point is they can't just jump ahead to the Supreme Court without having gone through the requisite initial steps, without having generated the basis in facts or the appropriate legal moment for the Supreme Court to get involved.
And I'll just add one more thing to that. One of the potential areas of dispute, we all say potential, which is why this is a premature lawsuit in the first place, is they perhaps think that they can file for condemnation in federal court under the theory that somehow Colorado conveyed a federal right of condemnation through the compact, which is simply not possible because we don't have a federal right of condemnation. If they file in state court, then there is not a conflict. We agree that that should be adjudicated in state court. any condemnation, but they have intimated and in fact seek with the Supreme Court some sort of extraordinary delegation from Colorado that is essentially contrafactual, since we don't have the ability to do condemnation through a federal court ourselves for state projects.
Yes, sir.
You're saying that you had been talking fine with Nebraska before. You're here today saying, using words like unfounded and unserious lawsuit, Nebraska hasn't done its homework. Can you seriously get back to productive and calm conversations with Nebraska?
Absolutely. I can tell you, and I believe it's the same with the governor, we are professional, we're very cordial, and we don't take this lawsuit personally. I believe this lawsuit is not ready for prime time. I believe the Supreme Court will not take it. And once that happens, that will lay the groundwork for the types of discussions and conversations that are appropriate. That's the way this works. And I will tell you, in many contexts, we do end up with litigation interspersed with discussions and working towards a constructive dialogue. I'll give you another example. The Rio Grande Compact has had litigation for over a decade with interspersed conversations with the federal government and between the different states. And that's one of the areas that lawyers are trained, which is to work towards constructive conversations where we can and to be ready to defend our positions where we need to.
Y'all seem pretty confident that the court's not going to take this. If they do, what does that process look like? What kind of timeline are we looking at?
The first step will be the court's decision whether to take the case or not, and I expect that will get resolved by the end of this term, June, early July-ish. If the court were to take this case, they would appoint a special master who would then oversee a process of discovery where facts would be unearthed, would be disclosed, and that would create the basis for the special master to write up an opinion evaluating the facts, making factual findings, evaluating the law, making proposed legal findings. That takes years. Once that was generated by the special master, the case would then go to the Supreme Court for a decision whether or not to accept the special master's report or whether or not there would be objections from either or both parties as to the report. That Rio Grande case I mentioned took over a decade to get from the start, which then generated a special master's conclusions, which then went to a potential settlement, which then went to the court. These cases take quite some time, and thus, if we do have this litigation route, it's not going to be soon before we get to a final resolution.
Any coincidence that you're filing on the last day of irrigation? You can answer that. I have a follow-up though.
The court's filing deadlines are coincidental to our irrigation season. That is an interesting coincidence, but this is driven by the court's filing deadlines, not by facts on the ground, so to speak.
On the question of bigger political questions, the current administration has shown no hesitation to lean hard on blue states on behalf of red states or red issues. Are you concerned at all that the executive branch could get involved and help Nebraska in its current battle with Colorado?
The merits of this case are clear, and it would be passing strange to have the Justice Department weigh in on a dispute between states without a federal interest and without a basis to make a point. I would be extremely surprised for the Federal Department of Justice to get involved in this case. All right, any final questions? Thank you all for your time.